Criminal Procedure Act. And it's very much important for you to know which document you'll be reading so that you're able to pass. Unfortunately, some of the documents I only provide to my students, the students that I teach each and every day on the Microsoft team. So guys, without wasting any time, let me show you the materials that you may use in order for you to pass. Firstly, some use this book, some prefer this one. Because by what people prefer. Some prefer this criminal procedure, which is the 12th. However, some go with the newest, which is the 30. It depends on your preference. Anyway, before that, you know that when you do a Criminal Procedure Act, you must have a Child Act. However, I have the beautiful document here which have everything about the Child Justice Act, which you will be needing it in the examination. This document is a very good document. You can see that it has everything for a man to survive in the examination. Let me put this one here on the other side here. Yes, here. Yes, it has everything that a man needs to survive in the examination. And this is because it has everything that is needed for Child Justice Act. What a nice document. This one is a very, very good document that you will need in the examination. But I only give to the people that they are my student. And the Constitution, and it goes by, if you're watching LME, you will know that you are dealing with Section 28, which cover the diverse issues such as civil and political rights, including the rights in the name of nationality of the children, the social instinct, the right to basic, everything about the child. And Section 28.2 requires the best interest of the child to be paramount, important in every decision taken in relation to the child. And then G made it clear that the child detention should be measured as a last resort. So child cannot just be arrested. And this is some sections there which are there. So because today we are not going to be dealing much with this, we are just going to show the documents that you will need in the examination in order for you to be easier to pass. If you have this document, it will become much easier for you to excel in the examination, because this document summarize or paraphrase everything that you need in the examination. So if you have this document, well, consider yourself pass. Consider yourself pass. And then another document that you will need in the examination, which I only provide to the people that I teach each and every day, is this one. This one is very much important. It's for criminal procedure, and you will need this document. If you don't have this document, it will be very hard for you to read and understand the CPR. This document is a very good document, and it's one of the documents that you need in the examination. Why? Because this document summarizes everything that happened in the court, which is the only thing that you need. So if you don't have a Criminal Procedure Act, you can actually come and check this document. This document will provide you any information that you need, and it's a very good one. Let me tell you. So, for example, let's start here. Okay. Let's start here in the criminal. Let's go and check which information we can speak about, and then we come and check on the other document to show you that one is summarized very well, and you will need that document in the examination. Okay, so guys, I'm Tembiso Munyai. By the way, I forgot to tell you, and I just graduated on Friday 19th of April 2024. It was a nice ceremony, and it was ecstatic. Yes. So let's start here. So let's just say which one can we pick up and go and search it. let me just say it's a trial court, maybe this one chapter 13, or let's say, let's come to the chapter 16, this one that deals with the joinder and separation of the trust. Maybe you want to know about joinders and you find that you are reading this book and you are not understanding. Well, actually, you can just come to my book, which I already know. This one, you just come to the joinder and accused. Then you go to the joinder and accused, then you know about it. Then you go to the putting of charge, based on the charge, the plea, everything that is transpired in court is well summarized here. The state case, opinion of case, everything is well summarized in this book. So for you, you can actually, a witness to remain out of court, witness blah, 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 blah. In the defense case, everything is summarized here. So actually, if you have this document, you have everything that you need for CPR. And then here we have a competency of witness, evidence of pointing out, about the confession, presumptions, cautionary rules. Those things are there in the CPR. So having this document, well, you may excel well in the examination. I can assure you, with this document, you will know about appeals, review, and then they are there. Okay, for example, now let's talk about this appeal and reviews, because this one are more important. You'll find them in the examination. So it's 179, and let's try to check our 179, which let's try to check 179. Which page is that? Oh, 179 is still very far. Okay, let me come here. Oh, I've passed 179. Let me just say, oh yeah, I've seen 180 there. Oh yeah, that means that their appeal, oh yeah, appeal and review. So 179, oh yeah. You can see we have appeals and reviews. Then we have a difference between appeals and review. And then they only tell you that this one is summarized well on that other study guide, the prescribed book. However, they even tell you about the summarized one, and they tell you about the appeal, and they tell you about the review. So for you to read this, you will actually learn more about appeal and review rather than going to this one. Okay, let's just come here and learn about appeal and review and see if it's understandable on the other book. Okay, we have appeal on the chapter 20. So let's just say maybe chapter 20. Trying to see. Let's just say chapter 20 and let's see. Okay. Oh, okay. Let's write the page. Let's say 445. Oh, okay. Let's just go to the 445 into the review, because it's not showing here. So let's check which page is this. 445. I thought maybe it will show, but it's not showing. Oh, this one is talking about the appeal. Who has the party to appeal and all those stuff of appealing. Then I'm sure we are going straight to this one, withdrawal of appeal. There's a lot of information here that may confuse you. And then, to be honest, even though you have not read too much, but coming here to try to tackle this thing may be very confusing, because you do not know. It's not well summarized. It's just a lot of information that is here. However, I try to go to the review. However, here it's written well, summarized well. They said just the section 304, of course, of the CPA does not empower the court on automatic review to increase the competence sentence, neither to refer the case back to the magistrate court to increase the sentence. There is therefore an anomaly in law of criminal procedure that the High Court could increase sentence on appeal, but not on review, even where the ends of justice require it. And I remember seeing one of the cases talking about this thing of increasing the competent sentence need in the review and in the appeal. And now you know that you know what the section 304 means. So they started by appeal, and they summarized the appeal very well. They speak about this procedure and the appeal, the sentencing and the appeal, and then everything that you need to know about the appeal. And then they talk about appeal from the lower courts, which it may be difficult for you to find in the criminal procedure book, but here you find it very well that in terms of section 84 of the Child Justice Act, a child offender may bring an appeal against conviction and sentence. I love this one because it's stated very clear and everything is clear. So using this book, there is a 100% guarantee that you are going to nail this examination. So, not further ado, let's try to check one case and see if we can let's check one question and see if we can able to answer this question well using this book or using the criminal procedure book. Let's go. Okay, let's go now with this the two books that I've showed you. There's two prescribed books. Now it's time for action. Okay, we have a 2022 May-June Criminal Procedure Act. It was 80 marks for 4 hours. It was just an open book, but even though it's open book, you must know that this exam is not gonna be easier like walking in the park, you know, or fetching water from the fountain. No, yeah. So let's go to question number 1. Hey, section 1. A is arrested on charge of housebreaking with intent to steal and theft. You know, we have done CPR 2602, CPR 2601, and I hope that CW, what we call CRW 2601 and CRW 2602. So we all have done that, unless if you want us to go back if you have not understood well. So we said A is arrested on charge of housebreaking with intent to steal and theft. That's A. So number 1.1, name the part of the law which regulates the essential elements of the offense allegedly committed by A. Name part of the law which regulates the essential elements of the offense allegedly committed by A. And number 1.2 says, name the part of the law which regulates the procedure to be followed in executing the prosecution. So those two questions now, if you can read them, you can understand what those questions want because you have done it. Of course, you have done it. Oh, I believe that you remember introduction to law. Oh, of course, you do remember introduction to law. So let's just say EF and then we go there. Oh, yeah, no. Oh, I wonder why you remember. Then there was this place, if you could remember very well, but it says South African can be divided into main division: formal law and substantive law. Formal or procedural law is part of the law which deals with procedure that must be followed in a legal proceedings. The rules that determine how court cases are decided or decisions reached, the way we act in courts, the kinds of evidence that are allowed, and so on, are contained in what we call formal law, which some people call adjective law. Okay, then substantive, which is material law, sometimes is part of the law, which determines the content and the meaning of the different legal rules. So this one determines the content and the meaning of different legal rules. But this one, the procedure, it determines the procedure that must be followed. That means, is it not clicking to you? Oh, of course, let's go back to the question. So what is going on is that it means that Civil Procedure Act is based on the formal law. Why? Because it decides how you act in court, how court cases must be decided. All those things are done in the procedure, Criminal Procedure Act. That's all. So now we know what is number 1. Well, now we know what is number 2. So let's go to number 3 without wasting time. Name the part of the law which determines the charges to be put against A and the so-called definition elements that must establish. Let's go to number 4, because this is clear. Everybody can see. If you can go and read again the difference between substantive and formal, you will be able to answer all those 3 questions. So now let's proceed. This was answer. This was very clear. You can see name the part which regulates the procedure. I told you that the Criminal Procedure Act is a formal. It's part of the adjective law, which it regulates the procedure that must be followed in court, while the other one, it determines the content. So it means that this one and this one, you know which one. The number 3 is still the same. You must find out whether it's substantive or whether it's a formal, but adjective. But you can actually see if it determines the charges to be put against A. You know which one is determined. Determining by statute is determined by different legal rules. Legal rules are part of what? Legal rules are part of the substantive. So let's go to number 4. If the case goes on trial, which burden must to be discharged to the court, and by whom? Clearly, we have to go straight to the really. We have to come back here. Really, I thought that we have finished with this one. Really, oh, okay. So let's just say, because it's ILW and we need to come back. Let's just say search and say. Okay, they made it clear. Yeah. They say that in the criminal case, the state must prove its case beyond reasonable doubt as the onus of proof. That was something that we learned from ILW. I'm taking you back so that whenever you see a case, whenever you see some of the things, you must know that you have done before. So you can actually get wrong for something that you have done, but you are not thinking much about those things. So the onus of proof rests with the state that must prove beyond a reasonable doubt. Is it not the same? If the case goes on trial, which burden must be discharged to the court, and by whom? The burden which the state must prove beyond a reasonable doubt. This is not the same, guys. The burden must be discharged by who? By the state. And what the state? The state must prove. The onus of the proof of the burden must be discharged by the state beyond a reasonable doubt. That was the 2 marks for nothing. And then, okay, let's go to number 115. Briefly discuss whether the type of offense mentioned above can or should affect the so-called presumption of innocence in any way. Well, this guy might have committed the aggressive or violent crime, but this guy is entitled to be not guilty until proven guilty. It's a common law in South Africa. When you go to court, you are not guilty until proven guilty, and the state must prove beyond a reasonable doubt. So this was the 2 marks for nothing. Another one, 2 marks, which was easy. You are innocent until proven guilty. A man is innocent until proven guilty. Okay. A is charged with offense of robbery with aggravating circumstances. The prosecutor requests the deferment of the case a few times before the actual trial starts. That is before A pleads to the charges and the witness testifies. Okay, let's go and read 1.2. Name the process which is applied by the court in deferring. Put forward to another date in case as indicated. Deferring. Okay, number 2. Name the process that is applicable if the trial had already started and witness led in testimony. Okay. So, have you ever heard about postponement? Have you ever heard about adjournment? I think those are the 2 things that you must know. So we are going to be looking at the difference between postponement and then the adjournment. Okay, let's go and use that other document which summarizes very well. It says that it occurs all too often in practice that the defense is ready to proceed with the bail application, but the state puts a spoke in the wheel by asking for a postponement. Some of the most frequent excuses tendered range from the investigating officer not being available. There are outstanding information regarding, for example, outstanding warrants, address of the applicant has not been verified, provide postponement. So those are the other reasons for not. So we can actually figure out that postponement is when the state is still not well investigated, they still want to further investigation, then they request postponement. So it's the state that requests postponement. Or maybe it's from your lawyer who said that we have not concluded this and this will require the postponement. Then you get the postponement. This is about postponement, right? Okay, I told you that with this document you are going to go far. Then the request for adjournment and the request for postponement. They said the following is applicable when application is made for adjournment and a postponement. The court can adjourn or postpone the proceeding to any date. That is regulated by section 168 of the CPA. Adjournment means an interruption of the proceedings, and postponement usually takes place prior to the commencement of the trial. So that's why I opened that one of the bail, before the trial, the actual trial. There should be a bail application, and the postponement takes place before the prior to the commencement of the trial. Now we know. The case can, however, also be postponed during the trial to a date in the future. And they said that it can actually even take place during the trial. Adjournment implies a shorter interruption. In general, adjournment or postponement should be granted to the accused to prepare himself for a trial, to obtain legal representation, to find a subpoena witness, to prepare arguments, etc. And then those are the difference between those two. The court can adjourn the proceeding to any place. In terms hereof, the court can decide adjourning the proceedings for an inspection in loco, also remove proceeding to another place, either within or outside the area of jurisdiction. When the state seeks a postponement, consider the following aspect before opposing the postponement: the date of arrest of the accused and how long has been in custody, the reason for the remand, and the previous history of any previous remained. Yeah. So now let's go back to the question now. We have read many things about postponement, adjournment. Now you know many of the stuff of the postponement and adjournment. Now we can actually say that 1.2.1, name the process that is applied to the court for deferring. We can say it's postponement. Postpone. They are postponing to another date. Name the process that is applicable if the trial has already started and witness led in testimony. Okay, we can say that is adjourn. You just adjourn for a shorter time, longer time, shorter time or longer time. So that is the process that is applicable if the trial has already started and witness led in testimonial. So we can say it adjourn. So the court will adjourn for a shorter time, maybe it's a break, they go for lunch, they eat, and they come back again. Now, when they set for another date, then it means that they have to postpone. So those are the difference between postpone and adjournment, which we have read about it, and those sections are there summarized very well. So now we'll continue with this paper if you want, but most of the important today I was just showing the documents that you must have, and I told you that you must have these documents. Okay, I was like, let me go, but I just want to go and look at this question. I feel like I'm loving this one. 2.1. Let's see. They said the three assailants. A, B, C are engaged in a crime of robbery at one of the jewelry store in the new build African Mall. During the ensuing fracas, a firefighter issues as the security guards at the jewelry store attempt to foil the robbery. F, one of the security guards, orders C, who is cornered inside the store, to give up. However, C responds by firing shots at F, who fires back, injuring C on the left leg. F apprehends C and hands him over to the police, whilst A, B make away with an undisclosed amount in fine jewelry and cash. C is held under guard in hospital, pending his appearance in court. Now, let's go to 2.1.1. This question has a 15 marks that is waiting for you, and you must know what to do. Number 2.1.1 says, discuss whether F's actions comply with the requirements for the use of force as set out in page 171 to 127. And they even give you a book so that you can actually summarize, but you still not summarize well and you still not get the good marks. So, so I'm going to show you how to answer this question so that you may able to answer this examination. Firstly, the question is asking, discuss F's action comply with the requirements for the use of force as set out on page 17. Firstly, we must find out if F has a right to use a force, or F have a right to apprehend. That was the question is asking. So number one, we are going to check whether F has a right to apprehend or whether F has a right to use force. SF. Remember, F is a security guard. Another issue that you must take into account is that A, B, and C were fleeing. So it's a resisting arrest. So in order to answer this question, you will go to that guide that I've shown you, that lovely book. Then you start from there, and then you know everything. That book is the one that if you don't have, well, you may not do good in the examination. So unless if the exam is multiple choice, even if it is multiple choice, that book is still. So this book has everything here, and it's talk about the resisting arrest, and they said that the use of force to overcome resistance against or fleeing from attempt to arrest is defined in section 49 of the CPA, which you can go down and see it. Justified homicide by an arrester who is by statute authorized to arrest or to assist with an arrest. For example, peace officer have the power to arrest with or without a warrant, or a private person who try to arrest or assist in attempted arrest. Section 42 deals with those things. So if you want to know whether that security guard has the right to arrest or not, you go and visit section 42, 1 and B. So they have already, and section 48 is authorized by section 49. Strictly requirements are laid down before an arrester can invoke the defense of justifiable homicide set out in section 49.2. So those requirements are on the section 49.2 of the CPA. According to the pre-revised section, where the person concerned was to be arrested for an offense referred to in Schedule 1, or was to be arrested on the grounds that he was reasonably suspected of having committed such an offense, and the person authorized under this act to arrest could not arrest him or prevent him from fleeing by other means rather than killing him, the killing should be deemed to be justifiable homicide. Section 49 was amended, and this section 49 no longer distinguishes between offenses. This essentially means that to kill a suspect during the arresting process is not allowed unless lives are endangered. The section is very important and should be studied through thoroughly. We should be borne in mind is that the force used in either overcoming the resistance of an arrestee or preventing his or her escape must be reasonable, necessary, and proportionally in the circumstances to overcome the resistance or to prevent the suspect from fleeing. And there were some cases of Pata, Minister of Safety and Security, then where they were discussing. So because this one was dealing with somebody fleeing and then the security guard, then if you visit those sections that are written, you got your 15 marks. It was an easier question. Then we won't talk about the use of dogs as an instrument, because there's no case that that question is not dealing with dogs. However, for you to go into examination, you must know about the use of dogs. What about the use of dogs? And they said that the use of dogs as an instrument of force should comply with the requirements as set out in section 49, subsection 1 or 2, depending on how much force was used. And there was a cases that they discussed, and this one of Motswana, and they said it was held that where an officer, knowing that his dog is aggressive and is likely to injure a suspect, and where colleagues were available to assist him, the risk of injury by setting police dogs on the suspect far exceeding the risk of injury from physical overpowering by the number of police officers. The officer therefore did not employ the method with least risk of injury to the suspect, and his conduct was not reasonable, necessary as contemplated in section. So there was another case. So there's a plenty of cases here that are here. And then after the cases, then we deal with the summons, how people are summoned to the court. And that one is very much important. It's something that you must know. Having this book, you are done with CPR. So yeah, today was this day, and today I was teaching you about the CPR and the importance of this book called CPR, which is the Criminal Procedure Act, and the other books that you may need to assist in the examination. Thank you very much for watching, and I hope that you will have a lovely day as I have a lovely day. And then we'll come back with some of the questions, try to answer them. If you have a question, you're allowed to raise that question. And remember, I spend most of the time with my students, teaching them and showing them some of the things that they want. In fact, the criminal procedure is going to be written on the 19th. Is it 19th or 18th or 17th? Somewhere, some date over there. So I will be very busy with my students. Thank you very much for watching. I hope that you enjoyed this video.